Production and distribution of City Club forums on IdeaStream are made possible by the generous support of PNC and the Raskin Family Fund, with additional funding from Robert Conrad, Cleveland State University, the Chautauqua Institution, the Cleveland Clinic, and the United Black Fund of Greater Cleveland, Incorporated.
Good afternoon, and welcome to the City Club of Cleveland. I'm Dan Moulthrop, Chief Executive here, also a proud member. And I'm pleased to introduce our speaker today. He's a professor of law at the University of California in Los Angeles and author of We the Corporations, How American Businesses Won Their Civil Rights. His name is Adam Winkler. 3 recent Supreme Court decisions, Citizens United versus the Federal Elections Commission, Burwell versus Hobby Lobby, and Masterpiece Cake Shop versus the Colorado Civil Rights Commission, have brought to the forefront of our national consciousness the issue of whether and to what extent corporations enjoy the protections of the First Amendment of the United States Constitution. Through all 3 decisions, corporations were deemed to have the same rights as individual persons as outlined in the Constitution, including freedom of speech, freedom of religion, and the freedom to spend as much money as you want on elections and advocating for political issues. These decisions were met with strong pushback from activists. That pushback has included a proposed constitutional amendment which would declare that corporations are not people and have no rights under the Constitution. Hundreds of government entities, from cities and villages to state legislatures, have offered resolutions in support of this amendment. While this fight seems new, Professor Winkler argues in his book, We the Corporations, that it's not at all new. Corporations have been lobbying for their civil rights since the ratification of the Constitution, he says. And they did so decades before women and African Americans by utilizing some of the same tools as individuals: civil disobedience and the American legal system. Professor Adam Winkler is a specialist in American constitutional law in the Supreme Court. His scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments, and according to a 2016 study, he's one of the top 20 law professors for citations by the courts. A Los Angeles native, he's a graduate of the School of Foreign Service at Georgetown University and New York University School of Law, which honored him with the Legal Teaching Award for Outstanding Alumni in Legal Academia. He also earned a master's degree in political science from UCLA. He clerked for David Thompson of the United States Court of Appeals for the Ninth Circuit and practiced law at Katten Muchin in Los Angeles, where he was on a litigation team that represented the late Michael Jackson in a highly publicized case. In addition to We the Corporations, which was named a finalist for the 2018 National Book Award for Nonfiction, Professor Winkler is the author of Gunfight: The Battle Over the Right to Bear Arms in America. Ladies and gentlemen, members and friends of the City Club, please join me in welcoming Adam Winkler.
Thank you so much for that wonderful introduction, and thank you to the City Club of Cleveland for having me and for all of you for being here today. Corporations have been at the center of some of the most significant Supreme Court cases in recent years. In 2010's Citizens United case, the Supreme Court held that business corporations have the same free speech rights as individuals to spend their money on election ads. Some people worry that Citizens United will lead to a corporate takeover of American democracy. But that's just silly. Corporations took over American democracy a long time ago. In 2014, in the Hobby Lobby case, the Supreme Court held that corporations had religious liberty rights under a federal statute and entitled the chain of craft stores to an exemption from a federal law requiring them to cover birth control in employee health plans. How did corporations come to have our most fundamental rights like freedom of speech and freedom of religion? Of course, corporations do not march on Washington with signs demanding equal rights. But yet, like women and racial minorities, corporations have fought since America's earliest days to win Supreme Court rulings recognizing their rights too. And they've been remarkably successful. Today, corporations have many of the same rights as you and me, and they use those rights to challenge laws that regulate business and regulate the economy. In law school today, students learn about civil rights, women's rights, immigrants' rights, even states' rights. But there has also been a 200-year struggle for corporate rights. The first thing to know about the fight for corporations for constitutional protections is that it's very old. The first Supreme Court case explicitly on the rights of African Americans, the notorious Dred Scott case, was decided in 1857. The first Supreme Court case explicitly on the rights of women was decided in 1873. The first Supreme Court case explicitly on the rights of business corporations under the Constitution was decided a half century before those cases, in 1809. The corporation involved was the Bank of the United States, at the time the richest and most powerful corporation in America, with branches from Boston to New Orleans. And the heated debate over the controversial Bank of the United States is famous for giving rise to the split in the Founding Fathers that led to the two-party system, as well as giving us a pretty memorable rap battle in Hamilton the musical. In Georgia, Jeffersonians who were opposed to the bank passed a law taxing the bank's assets in the Savannah branch, and the bank decided to challenge that law in federal court. The bank's case presented a familiar question: are corporations people? Or more specifically, are corporations citizens under Article 3 of the Constitution? Article 3 of the Constitution effectively provides, quote, citizens with a right to sue in federal court when they sue citizens of other states. And this provision reflected the founders' fear that a state court would be beholden to its own state's residents and its own state's interests, and if there was litigation against someone from out of state, that state court would likely be biased. And the Bank of the United States, which was headquartered in Philadelphia, argued that it too would be prejudiced if forced to litigate the lawfulness of Georgia's popular tax in Georgia's state courts. Now, of course, the framers were not thinking about corporations when they wrote Article 3 of the Constitution. And in fact, judging from the records of the Constitutional Convention and the state ratifying debates over the Constitution, it's pretty clear that the founders never even considered whether corporations would have the rights that they have established under the Constitution. In fact, but nonetheless, the Supreme Court, in an opinion by the legendary Chief Justice John Marshall, ruled that the Bank of the United States did have the right to sue in federal court under Article 3 of the Constitution. Marshall did not say that corporations were citizens as such. Rather, Marshall said that corporations had the right to sue in federal court because the people who made up the corporation, they were citizens. Now, even though the bank's lawsuit was brought in the name of the bank to recover the property of the bank, the Supreme Court said that, quote, essentially the parties in such a case are the members of the corporation. The first case to extend a constitutional right to corporations, Bank of the United States versus DeVoe, is one of the neglected landmarks of American law. You won't find it in any constitutional law casebooks. Yet it laid the foundation for 2 centuries of corporate rights cases to come. The right to sue in federal court, by the way, was also the very same issue in the notorious Dred Scott case years later. In that case, the Supreme Court held that African Americans could not be citizens under the very same provision of the Constitution that corporations could claim the protection of. Unlike racial minorities, corporations did have rights the white man was bound to respect. Now, corporations have not only fought for years to win constitutional protections, they've also been innovators in civil rights litigation. One eye-opening and disturbing example came after the Civil War in a series of remarkable cases brought by the Southern Pacific Railroad Company. When California imposed a special tax on railroads, the Southern Pacific assembled an all-star team of lawyers led by the illustrious Roscoe Conkling to fight back. Now, lawyers have played a starring role in all the great civil rights movements. You think of Thurgood Marshall in the civil rights movement or Ruth Bader Ginsburg in the women's rights movement. And corporate rights were really no exception. Among those who argued for the constitutional rights of corporations over the course of American history included Daniel Webster, considered maybe the greatest advocate ever in the history of the Supreme Court, argued more than 200 cases back in the early 1800s. John Quincy Adams, the 6th President of the United States, argued for the rights of corporations. And Ted Olson, the dean of today's elite Supreme Court bar, has argued for corporate rights too. Unlike traditional civil rights organizations, corporations have always had the resources to hire the best, most creative lawyers money could buy. Certainly, Roscoe Conkling fit this description. For nearly 2 decades, Conkling had been a leader of the Republican Party in Congress. He had even been nominated and confirmed to the United States Supreme Court himself, turning the seat down after winning confirmation. He remains, by the way, the last person to this day to turn down a Supreme Court seat after having won confirmation. He frankly admitted that the reason was financial. He was simply making too much money as a lawyer for the railroads. Now, the Southern Pacific Railroad's lawyers like Conkling first settled on a strategy of civil disobedience. They would simply refuse to pay the tax. And then, a half century before the NAACP's famous litigation campaign against racial segregation in schools, the Southern Pacific Railroad launched a groundbreaking series of what its lawyers called, quote, test cases. More than 60 in all, seeking a Supreme Court ruling recognizing expansive rights for corporations. The railroad's litigation campaign, like that of the NAACP decades later, was focused on the 14th Amendment to the Constitution, which says that no state shall deny to any person the equal protection of the laws. This provision was added to the Constitution right after the Civil War to guarantee the rights of the newly freed slaves. Yet Conkling argued that it was also written to protect business corporations. Now, the text of the 14th Amendment did not provide much support for that idea. It guaranteed the rights of persons. But there's one thing you should know about Roscoe Conkling was that he was not the type of lawyer who would allow a little thing like the text of the Constitution to get in his way. And Conkling told the justices that earlier drafts of the 14th Amendment's Equal Protection Clause had guaranteed rights originally to, quote, citizens, but that the language was changed specifically to the word persons to, he said, quote, embrace artificial persons as well as natural persons. Now, this was a pretty audacious argument for Conkling to make, but he was uniquely situated to make it. When Conkling was a young congressman after the Civil War, he had served on the very committee that had written the 14th Amendment. And in fact, by the 1880s, when he argued before the Supreme Court, he was the last surviving member of the committee that wrote the 14th Amendment. So there was no one there to refute his tale. He even produced a musty old journal that he claimed was a never-before-published record of the deliberations of the drafting committee of the 14th Amendment, and he said a close look at that journal would support his story. Now, there was one small problem with Conkling's account of the history of the 14th Amendment, which is that it wasn't true. We now know that the language of the amendment had never been changed from citizen to person the way Conkling claimed, nor do the records show that any member of the drafting committee ever said or implied that corporations would be protected too when the amendment was proposed and ratified by the states. As one historian who examined the evidence closely concluded, the trusted Conkling had engaged in, quote, a deliberate brazen forgery to win new rights for corporations. Now, the Supreme Court never ruled in Conkling's case, surprisingly enough, holding on to it for 3 years without ever issuing a decision. Now, some people think that it was a procedural snafu that stopped the court from ruling, but I suspect that Conkling's fraud was uncovered. Regardless, another one of the Southern Pacific's 60 test cases made it to the Supreme Court a few years later, this time without Conkling or any mention of his journal. And in the second case, the court ruled in favor of the Southern Pacific Railroad, although specifically avoiding the constitutional question. The court said, we're not ruling on whether corporations have equal protection rights under the 14th Amendment. But then the Southern Pacific Railroad's case took a bizarre turn. The court's opinions are published in official volumes, which are edited by someone known as the Reporter of Decisions. And traditionally, the Reporter of Decisions writes up a summary of the Supreme Court's opinion and publishes it right in the front of the opinion in the official volumes. And this makes legal research easier. A lawyer can pull it up, read the summary, figure out what the court has held before he goes into dives into the larger opinion. The Supreme Court's Reporter of Decisions back in the 1880s was a man named J.C. Bancroft Davis. Now, and Davis's summary of the Southern Pacific case said that the court had ruled, quote, the defendant corporations are persons within the intent of the clause in the 14th Amendment, which forbids a state to deny to any person the equal protection of the laws. Now, we don't know what motivated Bancroft Davis to include such an inaccurate summary when the court specifically said it was not ruling on that issue. But if you're one for conspiracy theories, you might be interested to know that J.C. Bancroft Davis had once served as president of the Newburgh and New York Railway Company. Justice Stephen Field saw the opportunity presented by Davis's inaccurate summary. If you're not familiar with Justice Stephen Field, he's one of the most colorful men ever to sit on the United States Supreme Court. He was the first justice from the Wild West, and he was reputed to carry a gun underneath his robes at all times. He's also the only sitting justice who was ever arrested for a crime, and the crime was murder. Now, of course, he was innocent, but perhaps we could say he was guilty of being willing to do almost anything to expand the rights of business corporations. When the Southern Pacific case was handed down, Field wrote his own opinion, arguing that the court had suffered a dereliction of its duty by failing to reach the important 14th Amendment question about whether corporations had rights. Nonetheless, Field, in a majority opinion a few years later on a related issue, drops a sentence. Well, as we held in the Southern Pacific Railroad case, corporations are persons entitled to equal protection of the laws under the 14th Amendment. Something that Field knew to be untrue and had even written an opinion arguing that we had not decided that. Yet in the years to follow, the Southern Pacific case would be cited over and over again for the proposition that corporations are entitled to 14th Amendment rights. Now, one reason Field was able to get away with his sleight of hand, if you will, was that he nevertheless captured the spirit of a Supreme Court that was entering into an era in its history known as the Lochner era. The Lochner era is a well-known historical era in the Supreme Court's history from roughly 1890 to 1937. And during this period, the court became known for being very business-friendly, and the court broadly interpreted the Constitution to strike down numerous regulations of business, including striking down federal child labor laws, zoning laws, minimum wage laws. Meanwhile, in cases like Plessy against Ferguson, upholding separate but equal, the same Supreme Court refused to read the 14th Amendment broadly to provide any meaningful protection for African Americans, the intended beneficiaries of the amendment. Indeed, between 1868, when the 14th Amendment was ratified, and 1912, the court decided a total of 28 14th Amendment cases on the rights of African Americans, most of them against African Americans. At the same time, during that same period, the court decided an astonishing 312 cases on the 14th Amendment rights of business corporations. Now, while the Lochner-era Supreme Court was indeed very business-friendly, the justices of that era also imposed new boundaries on the rights of business corporations. In a 1905 case, the Supreme Court said that corporations had property rights, but not liberty rights. Corporations needed basic protections for their assets, for their buildings, for their property, but the court refused to extend to corporations rights that were associated with personal conscience, individual liberty, and political freedom. In a case evocative of this term's high-profile controversy involving a bakery that refused to sell a wedding cake to a same-sex couple, the Supreme Court in 1907 held that a corporation did not have a constitutional right to refuse service to unwanted customers. The corporation that ran Tanforan Racetrack in California, later home to the legendary Seabiscuit, challenged a California law that required places of public amusement to admit anyone with a valid ticket. The company claimed that this law, an early anti-discrimination law, violated its right to freedom of association, calling it the equivalent of requiring a host to admit unwanted guests into a private reception. Nonetheless, the Supreme Court upheld the law. Calling the freedom of association a liberty right, the court said that this was not the type of right that a corporation enjoyed. In another instance of déjà vu, corporations challenged campaign finance laws that limited corporate money in elections nearly a century before Citizens United. In the early 1900s, some of the very first campaign finance laws were adopted, and they were restrictions on corporate money in elections. And in the run-up to Prohibition, corporations like the Lansing Brewing Company wanted to influence local elections on whether to go dry. And they challenged the constitutionality of these restrictions on corporate money. Yet the courts consistently and uniformly upheld these campaign finance laws, explaining that the right to influence elections was limited to natural persons, not artificial persons. The boundary between property rights and liberty rights established by the conservative Lochner Court was blurred, surprisingly, by the progressive jurisprudence of the 20th century. It began with the First Amendment, and the story of how corporations won First Amendment rights highlights another surprising aspect of the history of corporate rights, which is that corporations have often been innovators in establishing broader, particular protections for individual rights. Driven by the same pursuit of profit that leads businesses to be at the forefront and the vanguard of the economy, corporations have also been first movers in constitutional law, and they've played an influential role in shaping some of our most important individual rights. In the early 20th century, for example, the Supreme Court first began to strike down laws for violating the freedom of the press under the First Amendment. and some of the earliest and most influential cases involved newspaper corporations, such as the newspaper companies that fought back against the Kingfish, Louisiana's iron-fisted demagogue Huey Long in the 1930s. A boisterous, outspoken populace elected on the eve of the Great Depression, promising to make Louisiana great again, Long became angry when the mainstream media opposed his agenda. He accused the papers of publishing fake news. You can't make this up. And stuck them with a tax on their advertising revenue. Long said his tax, quote, should be called a tax on lying, 2 cents per lie. The newspaper companies challenged Long's tax in court, but the law appeared to be on Long's side. The Supreme Court had previously said that the freedom of the press only prohibited government from stopping publication of something in advance. In the newspaper case, nonetheless, the Supreme Court issued a landmark ruling in favor of the corporations, and the court held that the freedom of the press protected against any form of censorship, even if it wasn't a prior restraint. And corporations, the court said, were entitled to claim that right too. In a modern society, newspapers played an essential role in checking the government and encouraging democratic debate, and they were published by corporations. In the years to follow, business corporations would also be involved in many other landmark freedom of press cases, including New York Times versus Sullivan, establishing the right to criticize public officials, and the Pentagon Papers case. Indeed, if you enjoyed the recent movie The Post, you may have found yourself at the end rooting and cheering for a business corporation asserting its First Amendment rights. Now, the First Amendment rights of corporations greatly expanded in the 1970s, and Ralph Nader deserves much of the credit. The famed Crusader won a groundbreaking Supreme Court case that struck down a law that prohibited pharmacists from advertising prescription drug prices. Nader's goal, of course, was to help consumers who were often overcharged for their prescription medications, and because of the advertising ban, they couldn't comparison shop very easily. But Nader's victory in this case established 2 important First Amendment principles that have since been used not to help consumers, but primarily to help business corporations. The first principle was that speech on commercial matters, like advertising, was protected by the First Amendment. The court had for many, many decades said that commercial speech was not protected by the First Amendment at all. But under Nader's new doctrine, however, corporations were empowered to challenge a wide range of laws restricting commercial advertising, including successful challenges against laws mandating graphic warnings on cigarette labels, successful challenges of laws requiring public companies to disclose to investors the use of conflict minerals, and a variety of laws restricting the advertising of alcohol and gaming. Thanks to the commercial speech doctrine established by Nader's victory, about 50% of all First Amendment cases brought today are brought by business corporations or trade associations that represent them. The second principle established by Nader's victory was that the First Amendment protected the rights of listeners without regard to the identity or the rights of the speaker. Nader represented consumers, not the pharmacists who sold things to them. And so he didn't argue that the law violated the pharmacist's rights. He wasn't representing pharmacists. He argued that the law violated the consumer's rights, that they had an independent right to hear what speech the pharmacist might want to say. This became known as the listener's rights view of the First Amendment. And that theory would quickly be used to strike down laws restricting corporate money in elections. 30 years before Citizens United, in the 1970s, the Supreme Court first struck down a campaign finance law limiting corporate spending in a case called First National Bank of Boston versus Bellotti. And the case involved a Massachusetts law that prohibited corporations from spending money on ballot measure campaigns. And the majority opinion for the divided 5-4 court was written by Justice Lewis Powell, Jr. Just prior to joining the court in 1971, Powell had written a memorandum for the Chamber of Commerce outlining a program for the political mobilization of business. It was the era of Nader, of consumer rights, of environmentalism, and Powell's memo was a call to arms for businessmen and for corporations to fight back and protect the free market. Powell's memorandum eventually was widely shared, and today historians of that era credit that memo with inspiring businesses and businessmen across the country to become much more politically active. In the Bellotti case, Powell had the opportunity to turn his memorandum into constitutional doctrine. Yet after the conference in the case, the private meeting of the justices where they meet and vote on the case initially, Powell saw that his majority was quickly slipping away, as one justice after another expressed privately concerns about expanding the First Amendment rights of business corporations. Powell found his answer and maintained his majority by adopting the listener's rights theory that Ralph Nader had articulated. His opinion insisted that it was, quote, the wrong question to ask whether corporations had First Amendment rights. The campaign spending law infringed the rights of the listeners, the people who would want to hear what the corporations have to say. The identity and the rights of the speaker, Powell wrote, were irrelevant. Listeners' rights would also be used, by the way, in the Citizens United case. Justice Anthony Kennedy's opinion for the court in that case said that the identity of the speaker was irrelevant. All that mattered was whether the law at issue restricted the type of speech that was entitled to protection. Now, one of the most unexpected things about the history of the corporate rights movement, if you will, is the role of corporate personhood. Although controversial today, the idea of corporate personhood is actually a pretty well-established legal principle. All the way back in 1757, Blackstone, in his influential commentaries on the laws of England, wrote that corporations were, quote, artificial persons. Indeed, if you open up any introductory textbook today in corporate or business law, one of the very first lessons you'll see is that corporations are, quote, fictional but legally recognized entities or persons that are treated as having some of the attributes of natural persons. Now, corporate personhood does not mean that corporations are the same as you and me. It only means that a corporation has its own independent identity in the eyes of the law. The corporate entity is wholly separate from the people who comprise it, who finance it, who run it. Delaware Chief Justice Leo Strine, one of the nation's leading experts on corporations, says, quote, the whole point of corporate law is that a corporation is a distinct entity that is legally separate from its stockholders, managers, and creditors. That's why if you slip and fall at Starbucks, you have to sue the company. You can't sue the individual shareholders. The shareholders have limited liability because Starbucks and the shareholders are separate legal persons with separate legal rights and separate legal duties. Yet the Supreme Court has often ignored this principle, this core tenet of corporate personhood in corporate rights cases. Recall Chief Justice John Marshall in the Bank of the United States case, who said that the bank had the right to sue in federal court because the members of the corporation had that right. Or consider Justice Samuel Alito's opinion in the Hobby Lobby case, which argues that the birth control requirement burdened the religious liberty rights of Hobby Lobby's owners, the Green family. In these cases, the Supreme Court is rejecting corporate personhood, not embracing it. It is refusing to recognize what corporate personhood insists upon, which is a strict separation between the entity and its members. Indeed, if you think about it, if a corporation's rights are derived from its members, well, who are themselves people, well, no wonder corporations have all the same rights as people. Now, over the years, the Supreme Court has occasionally treated the corporation as its own independent legal person, separate and apart from its members. The surprising thing is that in these cases, the court has tended to limit and restrict the rights of business corporations. In an 1839 case, the Supreme Court refused to extend to corporations the privileges and immunities of Article 4 of the Constitution. The Privileges and Immunities Clause of Article 4 means that if you move from Ohio to California, you're entitled to all the same legal rights as a Californian. Corporations seeking to operate in the increasingly national marketplace of the early 1800s tried to use this provision to challenge state laws that restricted out-of-state corporations from coming in and doing business there. And the corporations argued that since their members were citizens, and they could go into any state and were entitled to do business on the same terms as locals, well, then the corporation should have that same freedom too. The Supreme Court, led by Roger Taney, ruled against the corporations. Although reviled today for his opinion in the notorious Dred Scott case, Taney had one thing that today's opponents of Citizens United might appreciate, which was that he was a corporate reformer who opposed expansive rights for corporations. According to Taney, a corporation, quote, is a person for certain purposes. When a corporation makes a contract, it is the contract of that legal entity, of the artificial being created by the charter, and not the contract of the individual members. In Taney's view, the rights and duties of the corporate entity were separate and distinct from the rights and duties of the corporation's members. The Supreme Court did something similar in the early 1900s in a case arising out of Teddy Roosevelt's famous effort to break up the trusts. Roosevelt launched a criminal investigation of the Tobacco Trust and subpoenaed the company's officers to testify before the grand jury. The companies claimed that this was a violation of their right against self-incrimination to require their own officers to come testify against the corporations. But the Supreme Court said it was not self-incrimination because the company and its members were separate legal persons with separate legal rights and separate legal duties. Fueled by the capital amassed with the corporate form and represented by the bar's best lawyers, corporations have been fighting for equal rights for more than 2 centuries. They've been constitutional first movers, pursuing novel civil rights litigation strategies and helping to breathe life into important constitutional provisions. And contrary to popular opinion, corporate personhood has not been the basis of expansive rights for corporations, and in fact, when it has been used, has tended to be used to limit the rights of corporations. Citizens United and Hobby Lobby are really only the most recent chapters in a much older story, the story of the corporate rights movement. In some ways, one of the least known yet most successful civil rights movements in American history. Thank you.
I have so many questions. Today we are participating in a forum with Adam Winkler, professor of law at UCLA and author of We the Corporations, How American Businesses Won Their Civil Rights. We're about to begin the Q&A with all of you, and we welcome questions from everyone, City Club members, guests, students, and those of you joining us via our live stream. If you'd like to tweet a question, please tweet it at the City Club, and our staff will work it into the program. Holding our microphones today are Marketing and Outreach Coordinator Julia Wong and Content Coordinator Bliss Davis. May we have our first question, please?
Professor Winkler, I wondered if you could talk a bit about the application of criminal law to corporations and perhaps using criminal law as a way to deprive corporations of some of their liberties when they've crossed the line in environmental cases or even other mass torts like big tobacco or big pharma.
Well, that's a great question. And if we want to think about the story of the corporate rights movement, we have to look at how the corporations won the rights of criminal defendants under the Constitution. And when we think about the Bill of Rights, we often think about it in terms of free speech, privacy. But when you actually look at the Bill of Rights, it's mostly about the investigation, trial, and punishment of criminals. Right? Everything from the Fourth Amendment to the Eighth Amendment is pretty much all about criminal investigations and punishments. And for most of human history, since the invention of the corporation back in Rome about 300 years before the birth of Christ, for most of that period, corporations were deemed not capable of committing a crime. The idea was that individual people who worked in the corporation could commit a crime, but the corporation was a fictional entity that couldn't come up with the proper mental state to have the evil intent that was necessary for criminal punishment. That changes around the turn of the 20th century. In the 1890s, 1900s, that starts to change. And part of the thing is the corporations become so big, the great trusts start taking over, and courts say, well, if these corporations can have this much power, they should be subject to criminal punishment too. But that then raises the question, well, are they entitled to the same rights as criminal defendants under the Constitution, such as the right to be free from unreasonable searches and seizures? And the tobacco company case that I mentioned was a case about Fourth Amendment and Fifth Amendment rights against self-incrimination. Today, we do allow corporations to exercise the rights of criminal defendants, and I think that makes a certain degree of sense. Right? We wouldn't want the government to just declare that, I don't know, Apple has violated the law by refusing to open up an iPhone of a suspected terrorist, and thus Apple could be punished criminally without due process of law. So that would be an odd thing to think that they wouldn't have those rights. The real issue with corporate criminal liability these days is an unwillingness of prosecutors to bring those cases. That while corporations can be held criminally liable for violating the law, there's very, very few prosecutions of the corporations themselves. Generally, there's efforts to go against the executives of the corporation, but not the corporation itself. And I think that that's an unfortunate development. It's that we know that corporations have corporate cultures, that they have their own unique identities in some ways, and if we can stop those corporations from committing crimes, I think we'd all be in better shape.
Building on your answer, it's hard to envision corporations taking any action without human beings being behind them. So how do we deal with what you just addressed in terms of the agent principal issue of who the member is and who the actual responsible party is?
Well, that's right. It's a very difficult one. Generally, in the area of criminal law and often in the area of tort law too, we can, if you're an individual officer, but you're acting within the scope of your employment, the scope of your job and your official duties, then that would count as the liability for the corporation, for the entity itself. But you're right, the principal agent problem is a significant one, and that's part of the reason why prosecutors don't bring these cases very often, because for fear of not really being able to show that it was the corporation or a corporation policy rather than the individual bad acts of a bad apple, if you will, that were behind the underlying effort. So that principal agent problem is a pragmatic difficulty. I think it can be overcome, but it's a very fact-specific inquiry because you have to be able to show that in some ways that the corporation was encouraging it, had a policy of it, or at least was willing to accept the benefits of it, and someone was acting within the scope of their employment. So there are difficult questions.
Professor Winkler, as a retired lawyer, I found your discussion of the progress, issue by issue, case by case, of how we arrived at the state of affairs today. As a human being, I found that discussion a very depressing description of how we arrived at the present state of affairs. Could you comment on the recent cases and personnel changes on the court in regards to corporate rights?
Sure. Yeah, I will say my story is not a hopeful one, right? My story is one of basically of how corporations have sort of stolen progressive constitutional reform time after time and time after time and used it for their own purposes. And that makes me less sanguine about the prospects for reform in the future, because thinking about how corporations will always have the money to be able to pursue these creative lawsuits to try to win more expansive rights. We have seen in recent years the Roberts Court expanding the rights of business corporations. We've mentioned the Hobby Lobby case, we've mentioned Citizens United, there's also the Masterpiece Cake Shop, the wedding case this past year. So the court has already been pretty vigorously expanding the rights of business corporations in that space. I think with new personnel changes, the addition of the two justices appointed by President Trump, Neil Gorsuch and Brett Kavanaugh, I think both of them are likely to rule strongly in favor of business corporations in future corporate rights cases, both in two ways. Both will see an expansion of corporate religious liberty. I think we'll see the court more friendly to the idea that corporations have religious liberty rights, and so they don't have to obey particular laws that infringe their religious freedom, such as laws requiring them to serve same-sex couples. But we'll also see it in a little bit more subtle ways in areas like a greater expansion of that commercial speech doctrine that was first established by that Ralph Nader case. One thing that if we look at the record of, say, Justice Kavanaugh as a lower court judge, he had very, very expansive rulings in favor of corporate speech rights in the commercial context, not just in the political context. So I think we're likely to see the rights of corporations continue to expand and corporations continue to very successfully use the Constitution to strike down laws that restrict businesses, restrict their autonomy, and regulate the economy.
Appreciate your sharing of the history and unearthing what has been buried for a very long time. My comment and question is, as you well know and as you have said, corporations were not mentioned in the Constitution, did not have intended to have inalienable constitutional rights. That was granted by what you say were innovations, what I would call usurpations by the Supreme Court, a very activist court. There was no intention to have corporations have these rights by a Republican form of government and those who founded this government of having we the people be the sovereign. So with their not being intended to have constitutional rights, society seemed to function okay. Business seemed to expand very heartily. And what constitutional rights of corporations have seemed to do is threaten the ability of a Republican form of government in a variety of ways and harm communities, workers, the environment, and the like. So if there was no intention, if there was no corporate constitutional rights to begin with, then what's the harm? To simply go back to where we once were, to a place where at least our founders felt is a better place to truly have sovereignty in a republican form of government where we, the people, are in charge over their created entities, since we are the sovereign and they were the subordinate?
Well, that's a great question and really captures, I think, why so many people find themselves frustrated by decisions like Citizens United, which seem to be giving a space in our public discourse and our civic life for corporations that many people feel they don't deserve and shouldn't have. I think you're right. There's really no evidence that the framers intended for the Constitution to protect the rights of business corporations. Note that there are several self-professed originalists on the Supreme Court who argue that the only legitimate way to interpret the Constitution is by lights of the original understanding of the Constitution in the founding era. And yet the founders, and yet they expand corporate rights. Justice Scalia tried to address this in his own opinion in Citizens United. I don't think he did a great job of it, but tried to make some sense of how an originalist could support expansive rights for business corporations. What would be the harm of going back? Well, I think there would be no harm in going back on some of these decisions. I think Citizens United was wrongly decided and gave too much of a space within our civic life and public debate for business corporations. But I'd be hesitant to eliminate all constitutional protections for business corporations. So for instance, if business corporations have no rights, categorically no rights because they're a corporation, well, then the New York Times Company has no rights as a corporation, and the New York Times Company could be censored by Congress. Fox News or CNN, all corporations, they could be censored. Even if you don't think about freedom of the press, think about other rights under the Constitution, such as due process and basic property rights. Right? Google and corporations all over the world all over the country have tons of assets. Should the government be able to take those assets without paying compensation? Should the government be able to fine Apple millions of dollars without due process of law because they don't open up a phone? If we say corporations have no rights under the Constitution, then we're saying they have no due process rights. They don't have a right to be innocent until proven guilty. If they don't have property rights, then their property can be taken for public use without just compensation. So I think there are very common sense, practical constitutional rights that corporations should have. And I do think there was something about that Lochner era intuition. And I don't think it's quite right in all its applications, but I think it's a good starting point. The idea that corporations should have property rights, that those are important for corporations to have. At the same time, they don't necessarily need liberty rights, such as the broad and expansive rights that the Supreme Court has recently held corporations to have. But that's really just a starting point for the analysis. And I think you're absolutely right that there's a lot to be said about the 100-year commitment we had to saying corporations do not have a place in spending money on elections, which is no longer the case anymore.
Professor, can you give us a sense of how the American treatment of corporate civil rights differs from or is similar to other modern democracies, European, United Kingdom, Canadian?
Yeah, sure. So the issue has not always been authoritatively discussed earlier in other countries. They don't have that same litigation that we have. What we find if we look in some European countries that corporate personhood is a well-established principle of business law around the world. The idea that a corporation is its own independent entity with its own independent rights, separate and distinct from the rights of shareholders or the rights of the people who form it. I think that is well established. But when it comes to constitutional rights, it becomes a more different story, right? And we don't see corporations having the same, say, free speech rights as corporations have here, at least to spend their money on election ads. Most Western democracies do not allow corporations to spend money on elections and have much more restrictive policies. At the same time, some corporate rights are very widespread. Corporations are entitled to due process rights in every Western democracy. They're entitled to property rights in every Western democracy. So some of these things are very common and straightforward. I think it's really that when we move into those liberty rights questions where it becomes a lot more controversial and the United States becomes a little bit more distinct.
Hello. You had spoken about how corporate rights were expanded under the Lochner era, and that matched a time of great corporate expansion through the Gilded Age and the Progressive era. Then you also talked about in the modern era how we're seeing it again under the Roberts Court. Does that Does that pattern hold true, like under the Warren Court and say early Rehnquist Court, where we saw expansion of individual rights? Did we see a recession of corporate rights? And if so, how? I guess back that up a second. How would we go about, or how were those, if they did happen, how did those actions come around?
Okay, well, that's great. Could I have someone with the microphone come up here too? That would be great. Let me answer your question though with regards to the, I don't think that the court is repeating what the court did in the Lochner era. And when we think about, in part because the Lochner era imposed boundaries that the court today is disregarding. And I think when we do think about the Warren Court era, that is an era that expanded rights for individuals, but also for corporations. The Warren Court didn't have a lot of big corporate rights cases, but did have some. And for instance, I said earlier that there was a 1907 case where the court said that the freedom of association was not a right that was enjoyed by corporations. But the Supreme Court in the 1950s changed that and said, corporations are entitled to freedom of association claims. Actually, that case was not in the context of a business corporation. It was in the context of the NAACP, Nonprofit Membership Association. But that precedent was then used by future corporations to fight for their rights too. Thank you.
Thank you, Professor Winkler. My question relates to what is a corporation. You addressed that a little bit in your book. They've changed over time, and they're continuing to change. To build on the question about different legal rights of corporations in different countries, what are your comments about the spread of multinational corporations, which in many ways seem more dangerous, and also about the corporatization of the world in the sense that structures that may have been considered nonprofits are increasingly viewed as corporate. And so is the success of business corporations spreading in any kind of malignant way to other organizational forms?
Well, that's a very good question. There certainly is. I don't know if I can say that the rights of business corporations are spreading to other organizational forms necessarily. Actually, one of the things I discovered in writing my book is in some ways the pattern sometimes goes the other way. That actually there's a lot of cases, or at least a few cases, important landmark cases, where the court expands the rights of corporations, but in cases that don't involve business corporations. So they involve nonprofit corporations or other such. I mentioned the NAACP case as an example. There was an early case involving Dartmouth College back in the 1819 where the Supreme Court very broadly protected the rights of business corporations too, in an opinion that was only in the context of an educational nonprofit, but the precedent was used thereafter by business corporations all the time. And so we do see a lot of sort of seepage or leakage or exploitation or adaptation, if you will. The corporations are exploiting these reforms. Business corporations exploit these reforms that come in other kinds of corporate entities that are not business corporations. But also thinking about the variety of different kinds of corporations. My book really focuses on business corporations. I think that's an interesting question. But there's a lot of other kinds of corporations. And one thing we want to think about, and it goes back to the question that was asked earlier about, well, what would be the problem of banning corporations from having any of these rights? Well, it's less of a problem, I think, with business corporations than it might be with nonprofit corporations, right? So Planned Parenthood is a corporation. The NRA is a corporation. If these organizations have no rights under the Constitution, as some constitutional provisions, some proposals for amendments would suggest, then those organizations have no rights either, including no right to engage in free speech, even though they're membership organizations where their rights might be different. So one mistake I think the court has made over the years is by failing to distinguish between different kinds of corporations and recognizing that different kinds of corporations might be entitled to different kinds of rights. And it's something that maybe the court should take more seriously.
Hello. Can you go in depth of some of the legal claims that were used to reshape the law?
Sure. In terms of the legal claims that were used to reshape the law, what we've seen in this book is really a story of how corporations made legal claims under one constitutional provision after another, and that they've been doing it for a real long time. That this is not something that's new, but it's really something that's very old-fashioned. One of the interesting things that I think is a key part of the legal claims is what I mentioned in the talk is that idea of corporate personhood. Like many, many people blame corporate personhood for decisions like Citizens United. But when you actually look at the legal claims made by these creative lawyers, they very rarely emphasize corporate personhood. There's occasional cases. There's that Southern Pacific Railway case that was an important case that was contrary to the trend that I'm talking about. But if you look, the vast majority of cases, what the corporations argue is not that they're people, but that they're associations. That they're associations of people, and that the people who associate together have rights, and they shouldn't lose those rights simply because they're in the context of a corporation. And that's the argument that's really been the winning argument, time and time again. And that's the argument that appears in Citizens United. Nowhere, you read Citizens United 100 times, you could play it backwards on your turntable. The kids don't know what that refers to at all. But you know, you can play it backwards on your turntable, and you will never find corporate personhood mentioned or talked about, or even referred to theoretically without by name. Instead, what the court says over and over again is that corporations are associations of citizens, disfavored associations of citizens, in fact. And so it's that idea of what I call in the book piercing the corporate veil, of looking past the corporate entity to get at the members, and that sort of disregarding of that traditional personhood separation that really is the essence of the legal claim made by corporations time and time again. Thank you.
Namaste, I'm Priya from India. Thanks for giving this very much insightful throwing light on your corporate laws. And my question is, how can you throw some more light on your international corporate laws? Like after Mr. Trump took place in president office, it assumed that globally that he rigged some policies for the international markets. So as per Indian concept, I would like to know it.
Well, that's a very interesting question. I'm not sure that I have the expertise to answer it in any great way, shape, or form, because of my book is sort of so focused on the past and sort of how we got to this moment. So I really don't have much great to say about that particular problem. But I will say that we are, as I mentioned earlier, going to see an expansion of the rights of business corporations in ways that will affect multinationals operating around the country, to respond to both these questions in some ways, and that will expand these rights. One of the difficult things is because of multinationals and because corporations operate around the world and today have investors from all over the world, it actually makes it kind of difficult to determine which corporations are really American corporations and which ones are not. Right? So Citizens United said that corporations could spend their money on election ads. But at the same time, the Supreme Court has upheld restrictions on foreigners contributing to election ads, and saying the court said that foreigners cannot spend money on elections, at least foreign citizens that are not in the United States, cannot spend money on election ads. But yet you have many foreigners who are invested in corporations, including American corporations, that are spending their money on election ads. So you've actually created, through the corporation, a loophole in the campaign finance laws that allow foreign money to come influence our elections in a way that the law is specifically designed to stop, and that the Supreme Court has said is okay to stop. You can stop that kind of spending. And so we just haven't done that's one of the additional problems that comes from these rulings.
You said that corporations did not have, if they did not have constitutional rights, you've mentioned some of the things that would possibly be a consequence, but corporations do have statutory rights already. Why wouldn't that be enough for corporations?
Well, it could be. So that's one possibility, is if corporations didn't have constitutional rights, you could pass a federal statute that would protect the rights of corporations in all 50 states, perhaps, or you could have state-level legislation protecting the rights of corporations. The difficulty here with these statutes is that it's a statute, so a statute can be overturned by a simple act of the majority. If corporations, all told, business corporations and non-business corporations, if corporations had no constitutional rights, well, what would be the first corporation that would feel that effect? Planned Parenthood. Planned Parenthood would be put out of business in 17 states in America tomorrow. Right? A corporation that would be and you could have a law that says, oh, well, we're going to protect the rights of Planned Parenthood. If it's a state law, that state law would just never be passed in those states, or an exemption or a special law would be passed exempting Planned Parenthood from those. So if you exempt corporations from constitutional protections, what you do is you subject them to the possibility of persecution. In some cases, that might not be troublesome, but I think we want to think about these prophylactic rules as coming up with rules that are going to avoid some of the worst situations. Statutory rights could be an effective way if we really stuck to the statutes. The problem with statutes is that we can overturn them at a moment's notice. Thank you. Thanks so much.
Today at the City Club, we're listening to a forum with Adam Winkler, professor of law at the UCLA School of Law and author of We the Corporations, How American Businesses Won Their Civil Rights. Our forum today is part of our Authors in Conversation series, supported in part by residents of Cuyahoga County through a public grant from Cuyahoga Arts and Culture. We're grateful to all of the residents of Cuyahoga County for their support of City Club programming through that public grant. Additionally, we welcome guests at a table hosted by Dave Nash, as well as students from the Cleveland School of Architecture and Design and Flow Homeschool Co-op. Student participation in City Club forums is provided by many foundations, including the William M. Weiss Foundation, and we thank you for being here today. The sale of Professor Winkler's book, We the Corporations, is provided by A Cultural Exchange. That brings us to the end of our forum. Thank you, Professor Winkler. Thank you, ladies and gentlemen. Our forum is adjourned.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.
Production and distribution of City Club forums on IdeaStream are made possible by the generous support of PNC and the Raskin Family Fund, with additional funding from Robert Conrad, Cleveland State University, the Chautauqua Institution, the Cleveland Clinic, and the United Black Fund of Greater Cleveland Incorporated.